Okay, welcome and thank you very much for coming to the final All Souls seminar of the term. This is a special and more than happy occasion because we have one of our own, Leila Ullrich, who is going to use this occasion to launch her book, Victims and Labour of Justice at the International Criminal Court, The Blame Cascade. So Leila is going to talk about the book for about 40 minutes. And we're going to be joined online by Christine Shoywal-Patel from University of Warwick, who will act as a discussant, and then the floor will be open, and then at the end we will be able to all have a drink to celebrate this important occasion. So Leila, the floor is yours.
Hello everyone, thank you so much for coming to the launch of my book. Today the title of the book is Victims and the Labour of Justice at the International Criminal Court, The Blame Cascade. As we're desperate to stop the violence and destruction which is currently being inflicted on Gaza, many of us are understandably hopeful about news that we received this week that the International Criminal Court's prosecutor is seeking arrest warrants against key Israeli officials as well as Hamas leaders for war crimes and crimes against humanity. And of course, there are also the proceedings on genocide currently before the ICJ. My book, however, is part of a more critical literature on international criminal justice, which cautions against that hope and optimism. In particular, I propose that we look at justice, the court's key concept, and raison d'etre differently. We often talk about justice as something that the court gives and that victims receive, almost like a gift. Or alternatively, we conceptualize justice as a legal process in which different parties participate. And in my talk today, I want to reverse the first image. If anything, justice is more something that victims give to the court rather than the other way around. And I also want to complicate the second image of the legal process by arguing that justice for victims is first and foremost work, plenty of work in fact, both for the court's practitioners, but also for victims. Effectively, I argue that justice for victims is work, which creates more workers. Now, this may sound strange at first, but it actually resembles a form of labor that we're all familiar with, namely what Marxist feminists call social reproduction work. All the birthing, nursing, feeding, educating, and caring, which is essential for reproducing the worker and his labor power, but are not usually seen or paid as work. We see the worker arriving at the factory gate in the morning and we see him leaving in the evening, but we don't see all the unpaid domestic labor which happens in between and in the background, which by reproducing the worker and his children also reproduces the preconditions for the capitalist mode of production. Indeed, capitalism has deliberately obscured the essential character of that labor by basically walling it off in the home and naturalizing it as part of women's role, thus invisibilizing and cheapening that labor. And I argue that something similar is happening in international criminal justice, where victim participation and victims' labor are essential for reproducing the court as a legitimate and working institution, but are not usually seen or recognized as work, neither by the court nor by the surrounding literature. Rethinking justice as labor then raised a whole new host of questions for me. What are the different forms of labor involved? Legal labor, bureaucratic labor, emotional labor. How are they valued and divided? Who does the labor of justice and why? And finally, what's the product of that labor? In other words, seeing victim participation as labor was only the entry point for me into a much broader study of the interplay between the court's victim engagement on the one hand and the broader capitalist economy in which it operates. And today I want to take you a little bit on a journey of how I came to see the court's victim engagement differently, which I've divided into 3 parts. In the first part, we will consider victim participation as a form of labor, both for the court's victim staff, but also for victims. And we will explore to what extent that labor resembles the unpaid social reproduction work that women do. In the second part, we will ask, why are victims and intermediaries undertaking that labor for the courts? Why do they agree to become the court's victims and intermediaries in the first place? And here we will take a look at the promise of justice and the ideological and disciplinary work it does on victims. Indeed, I argue that we need to think of the labor of justice as a dual form of labor. There is the labor that we do to receive justice, but there's also the labor that justice does on us as a particular type of ideology. In the final part, I want to zoom out a little bit out of the court's victim engagement and contextualize all that work in the broader capitalist economy. What is the product of all that labor beyond just reproducing and legitimating the court? And I argue here that victims in Africa, where the court tends to operate, are both the producers, but also the products of that labor. So people come to the court because they want justice. They are then recruited to work for justice. They become trapped in the contradictions of justice, and they end up as blameworthy capitalist subjects whose work is neither recognized nor valued. I'm not going to say much about methodology here, but I'm happy to talk more about it in the Q&A. But the book is based on a multi-sided ethnographic study of the court's victim engagement in The Hague, Kenya, and Uganda, where I did field work. I did an internship at the ICC in 2013, 2014, and then field work in Kenya and Uganda between 2014 and 2019. Including 134 interviews with the court's judges, lawyers, bureaucrats, victims' lawyers, NGOs, local intermediaries, and victims. Okay, first part. So when the ICC was first established in 1998, it was widely celebrated as a victims' court because it provides victims with extensive rights to participate in the proceedings and to receive reparations. And that was really novel at the time in international criminal justice. Yet now, 25 years later, I think it's fair to say that many scholars and many victims advocates have grown increasingly disillusioned with the court's victim engagement, even though for very different reasons. And I think we can sort of broadly distinguish 3 strands of the literature. The first is what I call the NGO perspective. So these are NGOs and victims advocates who very much pushed for the incorporation of victims' rights in the Rome Statute in the first place, but they increasingly complain that victim participation has become too distant, too legalized, too bureaucratic to be meaningful for victims who live in rural areas in the global south. Indeed, victim participation at the ICC has become ever more collective. It's sort of basically sort of a mass form of participation where hundreds and even thousands of victims are often grouped together and then represented by 1 or 2 lawyers in The Hague. Many legal scholars, on the other hand, counter that international criminal legal procedure was never really designed to accommodate the participation of hundreds and thousands of victims. And so trying to integrate them is not only not meaningful for them, but it also risks eroding the defendant's rights to a fair and impartial and speedy trial. Critical scholars, by contrast, often claim that victim participation was never really about including victims. It's really part of a much broader spectacle where the court uses the images of innocent passive victims in Africa who need to be rescued by the ICC as a way to raise money, basically, to build legitimacy, and to also reassure audiences in the global north that something is being done about egregious violence in the global south. So all three strands of the literature, even though they see victim participation very differently, some want more, some want less, they ultimately concur that victim participation at the ICC has become largely symbolic. It's not meaningful. It doesn't really do anything real for victims. And that's precisely the perspective that I'm challenging in my book, because I think it neglects how productive victim participation is, both as a method of creating victim workers for the court, as well as capitalist subjects for the broader global economy. And my challenge to begin with is methodological, because both the critical and the legal literature, they tend to focus on the victim's role in the courtroom or on the sort of visual and discursive representation of victims. And of course, if we look at the courtroom, the victim's role does indeed look rather limited. So you can see the victim's lawyers somewhere there in the middle, but you don't see any victims. But this overlooks what the court is doing outside the courtroom in the so-called field, for example, in Kenya and Uganda, where I conducted my fieldwork. And just to give an example, the ICC recently published these figures to represent its accomplishments for the year 2023. And we can see here that the first four figures, they relate to trial proceedings, and they're rather modest. But then the numbers suddenly start to climb. 16,000 victims participated in the proceedings, 1,600 victims received reparations, 70,000 victims benefited from assistance, over 34 million people reached in 16 countries, which suggests that much more is happening outside the courtroom than inside the courtroom. Indeed, victim participation looks like this, much more than like that. So just if you think back to the factory, just as we saw the factory, but we didn't see all the unpaid domestic labor that makes factory work possible in the first place, in international criminal justice, we tend to see the courtroom, but not the activities in the fields that underpin it. So what happens actually in the field? What do victims actually do when they participate in international criminal justice? Many victimologists would answer that victim participation is about victims having their say in the proceedings. It's about sharing their experiences of victimization. It's about engaging in truth-seeking and or receiving emotional closure for the harms they suffered. Many lawyers would emphasize that it's really about representing victims' views and concerns to the judges and to update victims on the trial proceedings. None of these answers is wrong, but they overlook something more obvious, perhaps even banal, namely that victims have to take time out of their lives to participate in the court's processes and thereby also localize and legitimate the court. Victim participation involves both the work of those who facilitated on the ground, so the court's field staff, victims' lawyers, intermediaries, but it also involves the work of victims. Consider, for example, this quote by a field assistant in Uganda who talked about her challenges of facilitating victim participation on the ground. She said, "They, the victims, still don't understand fully how it works and even what's expected of them. At the beginning, we had clients who were telling us that they were tired of attending meetings. But one would expect that this is something that someone who has chosen to participate would understand. This is their expectation. This is their duty. So this is something we had to go through over and over again and tell them step by step. Do you remember when you came in to apply? This is what participation means. This is what is expected of you, to share your views. The trial cannot go on without you giving us your views. It becomes pointless if we are to work without you." So here we encounter the rather disciplinary quality of participation. You've agreed to participate. Now you must share your views. As victims are roped into the court's processes, victim participation morphs from a legal right or a democratic measure where victims have their voices heard to a labor form where victims start working for the court basically for free. And victim participation at the ICC isn't exactly a short-lived commitment. The ICC's trials often drag on for years, even decades. In Uganda, the first trial, the trial against Dominic Ongwen, started in 2016 and is still in the reparation phase. And victim participation is also very risky labor. Victims often have to travel for hours on unsafe roads, crossing checkpoints, bribing police officers to reach the court's lawyers and outreach officers. And in those countries in which the government is hostile to the ICC's intervention, victim participation can become very dangerous labor indeed. Why don't we see or recognize victims' labor? Part of the reason, I think, is that victims in the global south, in rural areas where the court tends to operate, are usually manual, subsistence, and reproductive workers whose time is not valued, because all they would be doing with their time, like it's nothing, is plowing their fields and doing subsistence work which is not remunerated. Another part, I think, is that participation isn't seen as work because victims don't do it for money, but to receive justice. So it's their commitment to justice that makes them undertake that labor. And justice, like much of social reproduction work, could be therefore seen as what Marxist feminists call a labor of love. And love, of course, is something that we're supposed to give freely. But victims are not the only laborers of love in international criminal justice. Indeed, the court's victim engagement accepts plenty of emotional labor from its field staff and intermediaries. Consider, for example, how one victims officer in Uganda, how she described the work of facilitating victims' applications to participate in the court's proceedings. She said, "They, the judges, gave us 6 months to file applications after the confirmation of charges. One thing that struck me is that many victims, and I met with all of the 4,100 victims, for all or most of them, it was the first time that they ever sat down with someone to listen to them, to take down their story from their perspective. Doing this was personally, and I come from northern Uganda, so it was an interesting thing, but it was also sad because I didn't see how we were able to close the wounds that we were opening through the application process. It was emotionally draining. In fact, I got sick after the application process. Like it was manic. It was very fast. It was emotional. For me, there was just too much I had to deal with." Who ends up doing most of that labor? Victims' work is gendered and racialized because gendered and racialized workers end up doing most of that work. The darker you are, the closer you're to victims, the more emotional labor you do, the less valuable your work is. And I want to illustrate how victims' labor is devalued through feminization and racialization with the example of the court's use of local intermediaries. And now intermediaries are a range of local actors, including victims, family members of victims, community leaders, students, grassroots organizations, who help the work on the ground in its situation countries with evidence collection, outreach, and victims' engagement. The court's problem is that it structurally depends on intermediaries to be able to operate in 17 countries across 4 continents with a very limited budget, a lack of field staff, and very little time. This dependence, however, is masked by hiding intermediaries' labor. Indeed, the court insists that the function of an intermediary to the ICC is in principle unpaid, and it designates intermediaries as volunteers or friends of the court. One intermediary who I interviewed in Nairobi, she fumed about this. She was really angry. She said, "The intermediary question is one of those which make me extremely angry. With the court, we've had discussions since 2011. And what do they come up with? Some bloody guidelines, which intermediaries are supposed to sign. What for? You don't offer us security. Literally nothing of their work is compensated by the court." So to solve the contradiction of intermediaries being on the one hand, essential for the court's operations, and on the other hand, basically a cost-saving measure, the court has feminized their work, making them laborers of love rather than law. And the court's practitioners, for example, they often emphasize that it is intermediaries, it's their personal proximity to victims and witnesses rather than their professional expertise, which makes them valuable to the court. So it's love, not law. And you can see here how they refer to trust and feelings and culture. And indeed, by sort of associating intermediaries with reproductive values, culture, care, trust, feelings, their labor is hidden, whilst moral expectations are heightened, which then also stirs feelings of betrayal and outrage when intermediaries are not faithful, when they betray the court's trust, when they take advantage of their role, when they start gatekeeping. Indeed, it is often easier to blame people if they fail in love, not law. Think, for example, of society's relentless blaming of the uncaring mother, that unpaid essential worker who, as Jacqueline Rose argues, is the ultimate scapegoat for everything that is wrong with this world. And there's so much wrong with this world. Yet is the labor of justice really comparable to the labor of love that women are expected to perform at home? The labor of love myth, Sarah Juff and others have argued, no longer only mystifies unpaid domestic work, but has also infiltrated the paid sector, especially service work, of course, but also creative professions such as academia, art, journalism. If you do something out of love, if being an artist is your calling, your passion, you're expected to do it all the time and for very little or no money. Now you may say, okay, justice is nothing like art. And I think that's very true for those who work in prison or in immigration detention. But I think it's a bit different in the international justice sector. Consider, for example, those two quotes. The first one is from an ICC, from a legal officer at the ICC chamber, who said, "I was always fearless, I would say, and passionate. I remember being interviewed for this position. I told them, this is what I've wanted to do my whole life. This is it. This is my calling." And the second quote is from one of the defense advocates who actually went on strike in December 2022 in The Hague, telling journalists, "We are really passionate about our work. That's why we are here. We love it. We love working at the ICC, but the conditions are really, really poor." So the point is that the labor of justice, just like the labor of love, can be very exploitative. The court extracts a lot of unpaid reproductive labor across its different categories of workers. Victims' labor is completely invisibilized and unpaid. We don't even see it. With intermediaries, it's more complicated because they do push back and they demand compensation for their work, which the court then sort of counters by devaluing, racializing, feminizing their work. The court's victim staff are waged workers, but they're often precariously employed, and they do a lot of extra emotional labor, which is not paid. Yet international justice workers are still, by and large, relatively privileged legal workers who are waiting to climb up the ladder into better paid and more secure positions. But what about victims and intermediaries in rural areas in Kenya and Uganda? Why would they undertake that labor for the court? Why do they agree to become the court's victims and intermediaries in the first place? And that brings us to the second part. I'll take a sip of water. When I asked a victim of post-election violence in Kenya why he was working for free for the court, riding his bicycle from village to village to persuade victims to come to a meeting with the ICC's lawyers, he said, "Because I want justice to prevail." Does that mean that victims labor for the court because they believe in or because they want justice? I think it's a little bit more complicated. As I said at the beginning, we need to think of the labor of justice as a dual form of labor. There's the labor that we do to receive justice, but also there's the labor that justice does on us, what I call ideological labor. And to make us better understand that labor, I'm going to now read you an ethnographic vignette from an ICC community outreach event, which I attended in Gulu in northern Uganda in July 2019. Happy Justice Day to all of us, to all of you, the champions of justice, the champions of accountability, the champions of the protection of human rights. The ICC's outreach officer greets the crowd. You deserve that, so please respond. Happy Justice Day. Happy Justice Day, the audience echoes back. Thank you. Today is the 21st anniversary of the court. The court is now fully functional. A big blue banner hangs over a podium in the hall. Colorful figures dance on the white wallpaper behind it. The banner reads, Public Dialogue in Commemoration of International Justice Day. Theme, Humanity Against Crimes. The hall was first filling up slowly, but is now packed. The public has come to the dialogue. The ICC's outreach officer announces from the podium, we bring the court closer to victims. She points to the banner explaining, the theme of the anniversary is humanity against crimes. To achieve global peace and justice, humanity needs to be united. By now, we all know that without justice, there can be no sustainable peace. She then explains victim participation in the ongoing case. It was just a handful of victims who came to The Hague, only 7, but it was a good representation of victims. The court does not have the capacity to bring 4,000 victims to The Hague. She continues, it's a handful of victims who will benefit. We need to manage expectations. If you were harmed on the 31st of January rather than the 30th of January, you might fall outside the scope of the charges. It is the law. Victims who cannot participate in the ongoing trial can, however, still participate in traditional justice, amnesty, reconciliation, and nation building in Uganda. Then there's time for questions. A woman jumps up, she's a victim, and this is the first time she's attending an outreach meeting. She complains, the perpetrators are walking free. They're being protected by the government while the victims must fend for themselves. Her intervention is followed by a priest from Kitgum who demands that the court should change the law so that the suspect has to carry the burden of proof. The ICC's outreach officer retorts calmly but assertively, Ongwen is innocent until proven guilty. He who accuses must prove. Unfortunately, the law is like that. You are neither the judge nor the policeman. There are institutions to enforce law and order so that we don't take the law into our own hands. So listening to the outreach officer's speech, but also thinking about my interviews at the court more broadly, I was quite struck by how ill-defined the notion of justice was, how it was able to absorb so many different and even conflicting meanings. Global peace, traditional justice, amnesties, reconciliation, law and order, punishment. How can justice be so central to the court's mission and simultaneously so contradictory? And why do people in Kenya and Uganda, why do they come to those meetings? Why do they engage in justice processes, which often offer very little, very late? This justice paradox can be resolved, I argue, once we consider justice for victims as an effective mode of ideological subject production. Indeed, victims are interpolated by the court much more than they are persuaded by its merits as an institution. Louis Althusser developed the concept of interpolation to explain how ideological institutions, for example, churches or schools, how they recruit their subjects. So interpolation literally means to call somebody a name, mom, husband, wife. And by responding to that name, by turning your head, you also accept the social role and the expectations that that name attaches to you. And I think something similar happens with the justice ideology. It really works by assigning people a role in the process. You are the victims, this is the judge, this is the law. So if you think back to the outreach officer in Gulu, she doesn't really explain why Ugandans need international criminal justice. Why can't this be done domestically, for example? And indeed, her role is not to persuade people to participate in the court's processes, because outreach is neutral, it's non-political, it's independent. Instead, she's doing something which is arguably more effective. She basically designates the audience as the court's natural supporters. You are the champions of justice. Rather than being persuaded, people are being celebrated. They know that they celebrate long before they know why they celebrate. They learn that this is a happy day, a day to celebrate us, humanity against crimes, and that they deserve that day. This is all established in the first seconds of the outreach officer's speech. So just as the housewife needs to be interpolated through the romantic notion of love as a loving wife or a caring mom, to embrace her role, which also conceals all the labor she's doing, not only for her husband and her children, but also for the broader social system that needs her labor to reproduce itself. In the same way, victims are being interpolated through that elusive promise of justice, justice which is always to come at some point. Ideological subject production has both a celebratory and a disciplinary side. It has both a lighter and a darker side. Initially, the court calls and lures people to become its subjects. But once you declare yourself a subject, a victim, or intermediary, the discourse shifts as lofty justice promises are filtered through legal procedure. You can participate, but you cannot change the law. There are institutions to enforce law and order. Of course, victims want justice, but they often want much broader, more material, more reparative, more redistributive forms of justice than the court is willing or able to offer. Yet, as they engage with the court's officers and lawyers, they are slowly being disciplined into accepting and working for a much narrower legal version of justice. Indeed, observing a victims registration mission in Kenya, I was quite struck by how much the meetings between the victims' lawyers and the victims basically resembled a school class. It felt a little bit like sitting in a school class where the lawyers teach and the victims listen and learn. And of course, the first things victims have to learn is not to expect reparations, because reparations can only come when there's a conviction. There are lots of legal criteria attached to it. So victims are first called to the court as its subjects. They're then being disciplined as the court's subjects. And eventually, they also carry some of the blame of being the court's subjects. And that brings us to the final part, and then you're released. So what is the justice ideology for? Is the point simply to use or exploit victims and justice workers more generally for the benefit of international criminal justice and its institutions? Yes and no. I think most immediately, I think victims' labor is important for reproducing the court as a working and as a legitimate institution, especially at a time when the justice ideology has shifted. And I think you get a sense of that when you follow the court on Twitter. It constantly puts out images of judges visiting victims. I think the justice ideology has really shifted from seeing justice as something which is best judged from afar, from a distance, to seeing justice as a process that needs to be localized, engaged, participatory, and not only to be meaningful, but also to be marketable to donors, to states, to the broader public. And if you read Christine's excellent work on marketing justice, you learn more about how that dynamic plays out. More broadly, however, I argue that by becoming the court's ideological subjects, its champions, victims are also gradually formed as capitalist subjects. And I think that transformation becomes clearer once we consider the interplay between the moral and the material economy of the court. So materially, as I argued, the court works because feminization and racialization makes local labor invisible and thus cheap. And the court, I think, really couldn't work without all that labor, to be honest. Like, it wouldn't be feasible. Morally, however, recruiting people from affected communities to work for the court also makes it easier to blame them as unreliable, opportunistic, or lazy when things go wrong, as they often do. And many things go wrong with the court's victim engagement. Defendants are at large or acquitted, charges are not confirmed, witnesses retract their testimony, victims are not reached in time, states don't cooperate, cases collapse or stall, and there's not enough money for reparations. And there's a tendency at the court to manage these shortcomings and these disappointments by externalizing blame and pushing it down its labor chain. And this brings me to one of the concepts that I develop in the book, what I call the blame cascade. Now, it's often argued in international criminal justice, it's often argued that international criminal justice basically works through the binary of innocent victims versus wicked perpetrators, which then basically allows all the blame for mass atrocity violence to be channeled to that one defendant, that one racialized defendant who sits in the courtroom, in this case, Dominic Ongwen. He then shoulders all the blame for it. But I think this overlooks how the visible legal process of attributing and apportioning blame to the defendant in the courtroom is accompanied by an invisible institutional process whereby blame cascades down through the mundane, everyday, hierarchical division of labor, which means that blame effectively accumulates at the bottom where the victims are. So the judges in The Hague blame the victims' lawyers in Kenya and Uganda for being incompetent or opportunistic. The metropolitan victims' lawyers in Nairobi or Kampala blame the unreliable intermediaries in the field, and the entrepreneurial intermediaries blame the lazy victims. White men in suits in The Hague pass blame on to black men in suits in the court situation countries, who pass it on to local women's lawyers and NGO workers, who further pass it on to victims and affected communities in rural Uganda and Kenya. And what makes blame stick to victims is diffusion between moral and material processes. So the more you incorporate victims into labor and debt relationships, the more they become blameworthy, because we can blame people for not working hard enough, or for not being competent, or for not being reliable. And indeed, by engaging in the court's processes, people not only become the court's victims, they are also increasingly trained to become productive and reproductive capitalist survivors. And there's this whole sort of methodology around survivors. And I just want to give you one example of this. I think it becomes clearer once we look at the court's assistance and reparation work in the field. So the court, for example, the Trust Fund for Victims, which is the court's reparation and assistance arm, it has funded what's called village savings and loan associations. And those are basically microcredit schemes which target women victims and effectively turn them into indebted subjects, i.e. capitalist subjects par excellence. So women take out loans, they invest in businesses, and they also police each other in the collection of debt and interest. One victim of sexual and gender-based violence, she expressed her gratitude in the following terms. She said, "The microcredit was the biggest benefit I received. It gave me dignity and made me respectable. I could even afford to make myself beautiful. Without that, I couldn't have found a husband. Nobody wants to marry a woman who was raped, but he finds me beautiful because I can take care of myself." So in short, with the help of the Trust Fund, victims kind of become better wives and better workers. Now, it may seem a bit counterintuitive that victims should incur a debt as a form of reparation for mass atrocity violence, but it actually makes perfect sense within the logic of capitalist relations. So, for example, the Oxford Handbook of Reparations has said that microfinance addresses real concerns they have in the sector, that reparation payments which are not invested profitably may be wasted. So the gift of justice becomes the burden of debt. And it's often the local partners and intermediaries on the ground who do the dirty labor of disciplining victims in what Karim calls an economy of shame, which is forming around microcredits. All areas should be announced at the weekly meetings. Care Uganda, the trust fund's former local partner, instructs. Members should not tolerate fund losses caused by members' failure to repay loans. The village savings and loans methodology Care Uganda boasts has moved people from being idle to being very productive and busy. Many participants have adopted better work ethics and habits. People work harder, keep time better, and deliver on their word. In other words, what is at stake here is not simply the reproduction of the court through the labor of victims, but also the reproduction of global capitalist relationships by recruiting those at the periphery, at the global periphery, those who have been unproductive because of years and decades of war and displacement, into the precarious logic of capitalist relations. So through outreach, victim participation, reparation, and assistance, the court also, and the court isn't alone in doing this, it's just part of a bigger picture, the court also creates and disciplines highly gendered and racialized capitalist subjects in the global south who are supposed to stop crying, work hard, be peaceful, get married, repay debts, and accept their place at the bottom of the global division of labor. So to conclude, I started with two images, justice as a legal process and justice as a gift, something we give or receive out of love. And what I've tried to do is I've tried to revise both images by basically saying that both law and love are labor, and that labor is unevenly distributed in international criminal justice and paid. In fact, what looks like victims' empowerment, and of course victim participation is often seen as a form of victims' empowerment, might actually be a form of victims' exploitation. The gift of justice often appears more like a poisoned fruit. By committing to justice, by becoming laborers of justice, victims also commit themselves to a capitalist future. So justice for victims is not just window dressing. It's not just symbolic. It actually does real things on the ground, I believe. I think it also helps to create people in the global south, both as the court's champions, its supporters, who labor daily to make the court work, but also as global capitalist subjects. Now, I don't have time to say much about resistance, but of course, victims do also resist the very limited justice offering of the court. And I just want to end with a quote by Grace Khan, who is a victim survivor and a co-founder of a local women's survivor network in northern Uganda, who said, "People in northern Uganda are also saying that even when Ongwen is sentenced for his offenses, he should be brought home to serve the punishment, because there's a feeling that where he's right now in ICC detention, he's actually in a better place. We don't call it punishment. He should come, stay home, actually be taken back to live a normal life he was living, so that he can learn from the challenges that are coming as a result of how people are living now, the way people struggle to survive. People say that this is the greatest punishment that can be given to him. People feel that he's actually in a better position than them. He's living a better life than the punishment he deserves." So here, Grace is posing a rather uncomfortable challenge to the court's conception of justice, by basically positing that victims struggle to survive at the bottom of a racial capitalist world order might be greater punishment than Dominic Ongwen's 25-year prison sentence in Norway. That's it. Thank you.
So thank you, Leila, for the invitation to be part of, your special day today. I've titled the few words for today, Leila's Labour of Love. But I do want to begin by extending my heartiest congratulations to you, Dr. Ullrich, on this fantastic achievement. And as you mentioned at the beginning, what a week to launch a book on international criminal law. The OTP as you know, announced on Monday that it has requested the pre-trial chamber to issue arrest warrants for both Hamas leaders and the Israeli Prime Minister and Minister of Defense. Apart from the truly momentous accusations of war crimes and crimes against humanity against a Western leader, we have been reassured that about the labour of the ICC for justice. We're told that in many months of silence, there was in fact invisible labour by experts who had come under fire for not making a statement in solidarity with victims of Gaza, indeed whose silence had been widely remarked upon. Now all is forgotten. That they didn't speak up in the face of genocide. They were, after all, labouring behind closed doors for international justice. Who is to say, Leila asks in her book, about those receiving and those distributing justice, what work is more productive? So labouring for international justice divides labour, so that the benefactors are NGOs, expert panels, judges, prosecutors. The beneficiaries, on the other hand, are those receiving training, receiving justice. And Leila explained to us just beautifully how she asks us to turn this relationship on its head. So like Leila, and without coordinating with her beforehand, I too was drawn to thinking about the labour of love in relation to her marvellous book. Leila begins her book, in fact, with a preface on the unloved dissertation that preceded the book. Where did this unlove come from, I asked myself? Do we have to love the work we produce? And has anyone ever said, I love my dissertation? It was a question that, for me, turned from curiosity to a philosophical question about love and justice. Gillian Rose wrote about love to the effect that it becomes real by reckoning with limitations, your own limitations, other people's limitations, life's limitations. Rose was a professor of social and political thought at my home institution, the University of Warwick. She was a radical thinker and wrote Love's Work when she had been diagnosed with terminal cancer. The short book is a memoir written as fragments of her life and the people she loved. I've recently been reintroduced to a whole new depth of Rose's work from my own PhD student, Rosie Woodhouse, who is working on Rose's philosophy. There's an abundance, an entirely apt abundance of roses in this. Rose's philosophy in the context of housing neoliberalism and property. So coincidentally, I was rereading Leila's book in preparation for today about labour and justice at the same time as I was reading this short memoir on labour and love. Both love and justice require hard work, as we heard from Leila. Both are mostly unremunerated or cheap and cheapened. To express the pain of love, Rose quotes Yeats that no thorns go as deep as a rose's, again the rose. As Leila demonstrates in her book, much of the exhausting and painful work in international justice is done by victims and remains unpaid. This is particularly meaningful as we hear about the important work done by the OTP and the OTP's report of the panel of experts who worked on the brief report since January this year, working, of course, in a gap of 20,000 Palestinian lives lost. Leila enables a view onto the invisible labour that enables the reproduction of the industry. The work of victims is cheapened, they're feminised and racialised, so their work is valued in a different way to, say, an expert panel, even if that expert panel is working pro bono. So if I had a substantive question for you, Leila, then it is that your proposition to consider labour begs the question not only of reproduction, but also of production. So if we were to consider victims as workers, we might think really that in equivalence to those in the factory, we might think of the debt relationship differently, as well as alienation they experience as worker victims. In any event, the labour lens enables a far deeper understanding between international justice and capitalism. In contrast to justice, love's work can remain, I would argue, resistant to enclosure in Marxist terms. Building on the wages for housework which Leila reference, there is an important Marxist feminist strand that usefully looks at the ways in which unpaid labour of love is part of social reproduction. However, in contrast to Leila, Rose, I think, offers a different perspective. One fragment from her memoir in Rose's work captures this aspect of resistance really well. Rose relays in one vignette of her life how she, being Jewish and a philosopher, had been set up, along with other intellectuals, to act as a consultant to advise the Polish Commission on the future of Auschwitz. While in Poland, she describes a train journey where her attention was drawn to a man who stood for the entire journey. In Rose's words, tall and angular with a gaunt, beak-like visage, he seemed to bear accumulating suffering with majesty, as if generations of poverty and loss had pared away all excess to reveal without guise his true nature. Later, she meets this man again at the banquet she attends, and even later accidentally stumbles into the man's old family home, family townhouse full of beautiful antique furniture, which he had just recovered after 40 years. The man was, it turns out, Count Potocki, a former aristocrat dispossessed of his family belongings. Rose is profoundly moved by the Count's sadness, despite his recent restored property. Yet I wept, writes Rose, for this ruined and restored Pole. To my surprise, for I understood perfectly well that this reallocation of private property is designed to create a species of investment to lure capital back from the States, from the United States, and from elsewhere in the diaspora. Such investment will finally demote limitless aristocratic seeming to the limits of bourgeois effecting and procuring. So capital stands both inside and outside of this relationship of love. After forcing the Count to sell his labour as a translator, become a landless wage worker, essentially, living in poverty for 40 years, it is now his property that has been restored that is doing the work for capital. There is something, though, in Rose's deep feelings, her weeping, that offers resistance through love. Leila writes about the exhausting work of justice for the court staff and for intermediaries and victims. She describes this emotional labour of justice work in neoliberal times as something that anyone who has worked in the justice industry can easily relate to. She describes how Marxist feminism and Marxism gave her some tools to understand this feeling of exhaustion as labouring for justice and as creating subjectivities of labour, of capital. Remarkably, it is not laborious to read Leila's book. In fact, it is truly revelatory. For a discipline that relies so much on victims for its legitimation, it has notably little humanizing work on these victims. The Blame Cascade takes a look at what victims actually do, not just what they represent. Leila talks us through who they are, where they are, how they travel, what forms they fill in, how they communicate, how they live. This is an important humanizing effort, and I think echoes the weeping of I described in Rose's account, a labour of love. So I mentioned at the beginning that this was a philosophical question about love, but as the famous saying by Marx goes, philosophers have only sought to interpret the world in various ways. The point, however, is to change it. Leila, drawing on Marxist theory, and understands this, of course, warning us not to employ love as the unpaid labour that is done for justice. But with Rose, I think we can oppose love and justice rather than allowing them to collapse into one another or allowing them to be subsumed by the same capitalist systems. So as we look at the devastation of Gaza and Palestinian life, including, of course, importantly, academic life, which has been more or less wiped out with the destruction of all universities in the Gaza Strip. And we think about the way in which Palestinians may now be forced to labour for the ICC and to become capitalist subjects, as Leila described, through their labour. It seems to me that we need more labours of love than we do labours of justice. So congratulations again, Leila, on this book, and much love.
Thank you so much.
Thank you. Before we open the throw open the floor for questions and comments. Did you want to say anything?
Yes, yeah. Thank you so much, Christina. That was really beautiful. I think I just wanted to pick up on, I think you sort of raised 2 points. Sort of the first one is, what's the relationship between social reproduction and productive labor and international criminal justice? And the other one is the question of whether love can also be a site of resistance and not just a site of subjection, right? It's not, I know that the talk was quite negative on on love. When it comes to the first point, I think, yeah, I mean, obviously there's a big debate amongst Marxist feminists about whether or not social reproduction work is productive labor, because, you know, if you feed your kids and you bring them to school, are you producing surplus value for capital or not? That's like a big debate. And I think, I mean, you know, and there different people come down differently on that question. But I think the broader thing that Marxist feminists agree on is that whether or not you agree that whether that labor directly produces surplus value or not, it doesn't really matter, because that labor is essential for reproducing capitalism anyway. So without workers, no work, no surplus value, no profit. It's like a very easy. So women really are sort of sitting at the, in some ways, they're sitting at the lever of the whole system. You know, when women's work stops, everything stops, and that's the power of women. That also brings us to resistance. So I think for me, social reproduction work is what creates the victim worker, and then those victim workers, through debt, through their land, through their labor, become productive workers. So they then So the idea of justice for work is work, social reproduction work, which then produces more workers who are then productive workers. So that's how I make sense of it. And I found it quite productive because, as you say, Christine, I think there's often I feel like in international criminal law, there is increasingly an understanding that international criminal law is not just law, it's politics. We need to understand the politics of international law. We know there's states, we know there's power. But I think there's much less on the relationship between international criminal justice and capitalism. And to the extent that there is, it's often the idea that, well, international criminal law is an ideology that sort of then obscures and normalizes and legitimizes the underlying violence of the capitalist mode of production, all the structural violence that we don't see because it's slow and it's messy. But I think what I was interested in is to sort of try to also see those capitalist relationships and logics in the everyday operation of the court. So not just see the big picture, but also the small picture, the small things that happen, and just to try to understand all this labor. And I think it's important, especially at the time, you know, when there is a real participation mantra in not just in international criminal law, but also in human rights and development, in peace building. There's this idea there needs to be active participation of people. Active participation has become a bit of an unqualified good, right? A gift to people, something to democratize processes. And I'm not saying that we shouldn't do it, but I think we should be conscious of what it means and what it means to take people's time, what it means to take people's labor, what it means to take people's knowledges, and not just take that for granted. And then just, sorry, now I've been going on, but the last point on how love can also be a form of resistance, I think that's really important. And I think one of the key ways in which I saw resistance in northern Uganda was by people just prioritizing their communities, the reproduction of themselves, their families, their communities over the international justice industry. So people would come late to the court meetings because they have to first go in the morning to their fields and look after the subsistence crops, right? That's what makes them survive. So they'll come late. And then the court's lawyers are annoyed because, you know, they have to wait. And so there were all these little reproductive symptoms, I call them, where people basically asserted the value of life making over profit making, where they said, no, this is not what we prioritize. We prioritize our love, you know, the way we live it in our communities. So not to romanticize it, but to see that it can be both a side of subjection, but also a way of mobilizing resistance, because ultimately whether there's capitalism or not, we will have to find ways of, you know, meeting our needs and reproducing ourselves. So that is essential work and will always be, and thereby perhaps it's prefigurative in some ways in terms of building another world. Yeah, sorry, thanks, Stephen.
Thank you. Okay, we have plenty of time for comments and discussion. So the floor is open. Catherine.
Thank you. That was fascinating. Very interesting. I have a question about to what extent, what do you think make the dynamics of the international criminal law different to the dynamics that happen in domestic courts? Because in domestic courts, let's say where you have victims of sexual violence, victims of domestic violence, they also have the burden of making the trial work. Without a victim, the court can't provide justice. They're not being valued. Often court sessions are postponed, victims are informed late, they're taken for granted, similar to what you've said. So they're unpaid, they're taken for granted, they're being blamed when victims are withdrawing their testimony, they are not cooperating anymore. So there is the blame cascade as well. So you've got some of these aspects in domestic court settings. And I was wondering, what makes it different? Is it the magnitude of the number of victims? Is it the length and traumatic nature of what they have to report to? I've done some work some years ago on the number of interviews victims are going through in the process of court cases coming to the international court, and the hours and hours of interviews they have to give, and also the emotional impact it has, and the number of victims that break in the process and who can't continue giving evidence because they are so traumatized. Is it that magnitude of the number, or the intensity of the problems, or is it also then the turning the victim into a capitalist subject through the microcredits or the reparation? And what would happen if you have cases where there isn't reparation? Is that then more similar to domestic court?
Yeah, I think that's a good point, and I think it's not. I mean, I think I became aware of those dynamics. I sort of started to see victim participation as labor in that context, but I totally think it exists in probably all institutions, right? And I think there is something about criminal justice, because blame is so central as a concept to these operations, and it has to go somewhere. And often it's not enough just to give it all to the defendant, especially, I think in international criminal law, it's magnified because the crimes are so big, right? In Uganda, it's like a 20-year-long conflict, like 90% of the population was displaced. Surely one person can't really shoulder all that blame. So I think there's a similarity, but there's also a difference, and I think it comes with the global nature of the process and the way in which it sort of brings together the global north and the global south in ways that are quite problematic, right? In the way in which, I mean, and I think the kind of what we did, the quote that we ended up with Grace, right, where she basically said that the problem is the injustice of the status quo. The problem is the injustice of being the lowest rank in a global order, you know, and that's sort of the place that they are basically asked to accept as sort of the normal thing. That's where they belong, right? And I think you have that. I think you obviously have that power differential as well in domestic criminal courts, because victims tend to be, you know, more often feminized and racialized subjects, and so there's that power difference between the court and the victims. I think it's just in international criminal justice is magnified, and I think also in a domestic setting, people are not they're already integrated into capitalist relationships. More, I mean, I'm not saying that capitalism is new to Northern Uganda. It's not, but it's still at the periphery, right? So people are actually subsistence workers. They have different ways of thinking about time, thinking about community, and so being sort of pulled into these processes is quite a transformation in the way people operate. And so I do think it's sort of, there's something sort of more profound in the trying to recruit those people at the periphery into the logic than perhaps in a domestic setting where, you know, victims are already part of that logic. So the court putting that labor on them is sort of perhaps less of a disruption of their normal life. But it's a question of, I think it's a difference in scale rather than kind. Thank you. Thank you.
Great. Thanks, Leila. Congratulations. Wonderful to see the book out, and thank you, Christine, as well, for such fantastic comments. And I suppose, you know, one of the great things about the book is that we've seen these sort of sustained critiques of international criminal justice for a while, but this book gives a really new way of thinking about it. And I suppose my question comes from that of what is the move from the critique that you raise? Because we're obviously seeing, and you and Christine are working on this, on the abolitionist move away from international criminal justice generally.
Mm-hmm.
But I was also wondering about the move that the Marxist feminists in relation to, you know, thinking of Silvia Federici's work on wages for housework, as Christine spoke to and your book refers to. But their move first is actually to monetarize that social reproduction. But then to monetarize that social reproduction in the international criminal justice sphere seems to take us back into the logic of the disciplined capitalist subject that you identify in those in the sort of social programs that are then part of the reparations packages. And so I wonder what that wages for housework move could look like. Is it land as reparation? Is it, you know, is it movement as reparation? You know, what is this different way of conceptualizing the injustice open up for us?
Yeah. Oh, thank you so much. That's a brilliant question. So I think, I mean, yeah, I think you're right. The obvious next question is, okay, so what are we going to do with it? Does it mean we should pay victims for their labor? And part of me thinks yes, but I think the Wages for Housework is an interesting campaign because I think it was a little bit more complicated, as in, so this was a campaign in the early 70s when Marxist feminists organized and demanded wages for housework. But the thing was that it was really more about making that work politically visible. That was really important. And I think that's really important here as well, making that work politically visible and asking the question of its value, not just its monetary value, but its social value. And I think Wages for Housework, the idea was not to create a world of waged houseworks. The idea was really to create a world without housewives, you know, where this work would be socially shared and collectively valued in new ways, right? There was a way in which the asking for money, asking for wages for housework was just a strategic move, you know, because obviously all that labor can't possibly be paid, you know, the whole system would collapse. And so it's a revolutionary move that really forces us to think about this labor differently, value it differently. And so I think the same applies here. The move is not, okay, let's just pay victims and good it is. So, but it's more like, oh, if international criminal justice depends so much on the labor of victims, do we need to think about them differently? Do we need to think about it differently? I think the question of reparations is really important, and the question of what next once we have that insight. I think land, for example, is one of the things that victims always ask. And I think that's also where, you know, the capitalist dynamics become so clear because, you know, the court operates in northern Uganda. And I was asking people like, oh, and so what do you think of the court and justice and da-da-da? And they were like, our land is being taken by corporations. Like, this is all happening at the same time in the same space, you know? And so trying to see the relationships between those processes, seeing them as connected, not as, because I think in international criminal justice, it's seen as separate, right? Oh yeah, there's sort of land grabbing going on, but it has nothing to do with the legal processes we're doing over here. No, they're connected. And in fact, victims often demand exactly that, land as reparation. So that could be a move, like ideally, of course, with the idea of, you know, not just giving it as private property, but perhaps sort of trying to think of communal forms of land, which are still dominant in northern Uganda. So I think that would be one move. The other move, I mean, I think now we see actually in the ongoing reparation decision that victims have had some leverage. So for example, they have been saying, we don't want any of this vocational training, microcredit stuff. You know, we've had this, and they actually wanted money on the hands. And they said, even if it's a small amount of money, it's better than nothing. And actually the court, I mean, we'll now see whether they actually received the money, because the court gives these astronomical reparation sums and then has no money to pay it. But you can see that, you know, there was a pushback here, which I think has worked and is perhaps an intermediate, you know, a sort of non-reformist reform, something that sort of leads on the way.
Thank you very much. Yes, thank you very much, Leila. This is really great. And also, Christine, that was a good discussion. The question I was going to ask first has also been touched on a little bit by the first question, actually, which I think is very, very important for us to understand, because you asked about the different systems at the ICC and at the domestic level and how the victims participate or how they're treated. I think it's important to note that in the domestic systems, and we're talking about different legal systems here, international criminal law, and then at the domestic level, it's still fragmented where you have a formal justice system and an informal justice system. But I think what is important to note is that victim participation is not present in the domestic systems. And that's in Kenya, in Uganda, and different countries that inherited the English system of common law. So victims have been absent from trials. And so the ICC in this particular case is the first opportunity where victims are invited. So that is new. And I was going to ask whether you think that actually the ICC in this case is just trying to leverage on the gap that, you know, victims have in the systems where they're not recognized, to leverage on that to visualize them or to racialize them. I think that is important because you mentioned, I think the first question, that maybe the victims in the domestic systems, maybe the way they engage is maybe not very active. But what sort of engagement? Because victims do not participate in the domestic courts, formal systems. But even in the informal courts, I mean, at the local level, in northern Uganda, for example, like, you know, traditional justice mechanism, where a lot of these same people participated, the participation there is not because they are victims, it's because of the community, and it's more because of survivors. So I think this is also important, that the way in which the people are labeled, one person is labeled by the ICC as a victim, and then by this community as a survivor. I think these are different distinctions that still can inform us how we understand how people participate or are racialized. When they're working with the ICC, for example, all the victims, because they're participating, but working with the government, for example, which has a primary obligation to work with, you know, the survivors or the community, they don't even consider themselves to be victims. You know, they're just survivors like everybody else. So I think that is something that is equally important, and I'd love to hear your comment on that.
Yeah, and no, I think that's a very important point, right? That sort of for many domestic systems, participation is absent, and that's a problem. I think the issue is just, and I think that comes a bit out in the outreach officer's speech, right? The issue is a little bit, what's the point of participation in a very top-down arrangement, right? I mean, law, like the way international criminal justice, it's statute law, right? There's a statute that is being applied. There is a set of actors who play a role. So participation is not democratic in the sense that it can really really sort of influence or change very much about the process, right? It's not to design to be that type of process. That's not how the law operates, right? So there is a bit of a tension of sort of combining participation, a democratic measure or a restorative justice measure with a system that is not really designed to be changeable from the bottom up. And I think you're also right to say that it's really important to note that there is this whole issue around who gets recognized as a victim. And as you said, it's the problem with the International Criminal Court is that it has very selective charges. So it comes in, there's a 20-year-long conflict, and it looks at 4 attacks on IDP camps at particular, on particular days, and if you happen to be one of the lucky ones, in square quotes, who happen to be victimized on those days, you become a victim recognized by the court. And if not, then you sort of are part of the sea of others who are not recognized. And there's some irony or some kind of strange analogy here with like being a worker, right? Like if you're a worker, you're lucky because there are many people who are unemployed who don't have jobs. So you're really lucky to have that position, which makes you exploitable, right? And it's similar in international criminal justice. You're really lucky when you're a victim recognized because the vast majority of people aren't. But then you're also laboring for that process, right? You're enlisted in that process. And you also, I think that's also part of the disciplinary dynamic. Because you're one of the chosen ones, one of the few, and because your status is precarious, there might be a change with the charges and the next day you won't be a victim. There might be, like there's so many different factors that can happen in the context of the trial that means that you lose that recognition. So that really makes you invested in the process. It really makes you work hard, because in Uganda, it's 4,000 victims who are participating out of 50,000, right? So there's the whole complexity and contradictions of being in that position, right? Where, victims do hold on to that status and they valorize it and they valorize the court and they valorize the justice. But there's also that sort of darker side, when over many, many years, people are putting a lot of resources, which could also have gone elsewhere, right? That's always the question of, what else can you do with your time? What else can you do with your labor? What else can you do with your knowledge? Than working for international institutions. Thanks so much.
Thank you so much for genuinely a very, very interesting presentation. And I think my question also touches on a little bit the question of victim representation and on resistance and abolition, which the last 2 questions touched on, which is, I think on the one hand, of course, there's a very important labeling effect to being recognized as a victim by the courts. And on the other hand, the court still represents to a very large degree a retributive model of justice. So then on the one hand, I can imagine that a lot of people are pulled into that system, into being a victim for the ICC, that aren't necessarily in agreement as much with the ICC's model of justice. However, then I do wonder, are the ones that are participating more wholeheartedly, that really are doing that most enthusiastically, are they the most retributively minded? And in that, is the ICC also displacing other models of justice? And then if so, how is that being resisted on the ground by, people who might be convinced otherwise?
No, I think, that's really, that's a really good question. I mean, the funny thing is, of course, that, victims come to the meetings and they're often very critical of the court, right? It's not that they, they, as you heard in the meeting, right? They say, why doesn't the defendant, why doesn't he carry the burden of proof? We should change that. So they're critical. They don't, they're not, they have very complex views. But the point is that they still come to the meeting. That's the beauty and nastiness of ideology, is that you practice it even if you don't believe it, like you take on that role, you practice your role, you're a student, you're a victim, and that in itself has a certain effect of making you into that role. And I think that the court's sort of outreach, and especially the victim engagement, the victims who are participating in the cases, because they meet regularly with the lawyers, they do take on those, they do take on a much narrower idea of justice than they started with. So you would often have, I remember one lawyer telling me that because they always have to manage victims' expectations when it comes to reparations. So when new people come and ask about reparations, he would then ask someone in the meeting, a victim who already has been through the training, to explain to the newcomers why they can't just expect reparations. So there's a sense in which then it becomes almost like a fact of the community that, oh, we can't expect reparations. So there is definitely that teaching effect that you take on over time. And yeah, it does push people into a more retributive direction. Which, and as Tony mentioned, you know, in Uganda, there are more restorative, more local justice processes also happening at the same time. And there's always a danger of a displacement effect. And I think I was very surprised when victims said, yeah, we're going to sue the court. We want a high, like, yeah, I think they become quite legalistic in the process of being sort of socialized into their roles as victims, and that can be problematic in terms of moving away from broader ideas of justice.
Yeah, thank you so much, Leila. That was absolutely brilliant, outstanding, and all the amazing adjectives that you can give to this presentation. I look forward to actually reading the book. I have two questions, which I hope is all right. One is more on the methodology, because I'm sort of coming from field work, and I was kind of curious because this was a multi-sided ethnography. It took you a lot of years to develop the kind of theoretical framework that you are proposing in this book. And I was kind of wondering, at what point in this process, like, was there a specific site that kind of inspired you to rethink all your findings? Was there like a particular trigger moment that sort of thought, okay, maybe this is not about what I initially thought it's going to be like, but it's about labor? That's something in sort of like the research process that I'm curious about. And I was also curious, given that I'm sort of coming from the restorative justice side, whether you had the opportunity to also maybe observe some of the restorative justice proceedings in those places, and whether you feel some of the sort of types of labor you presented here are replicated in those spaces or, as well, or whether laborers existed in the first place, whether it looks different. I think that would be also interesting to know.
Thank you so much, Julia. Yeah, I think that's a brilliant question around theory. I think Carolyn will remember that there was nothing on labor in my dissertation, the unloved dissertation.
I missed it. If there was, I was sitting here thinking, I missed that bit.
There was none of that in the unloved dissertation. I think that's always like the way theory and, you know, your data comes together is always very complex, right? And I mean, I wrote this book during the pandemic, right, when I was stuck at home, and labor suddenly had become politically much more visible in the moment we lived through. And I was starting to read more Marxist feminist theory while I was returning to my data. And I think, so for example, I didn't ask any of my interviews about labor at all. I asked them about the challenges of victim participation. What are the challenges of it? And then people would say, oh, it's difficult because victims say they're really tired of attending meetings. It's so many meetings. Why should they do it? And then field staff would talk about the, you know, the emotional labor. And so it sort of came together, you know, sort of, I sort of saw something in the data that I hadn't seen before because I didn't have the theoretical lens, but also I didn't have the, I guess, the political relevance of the moment that really made me look at this differently. So it wasn't, I think it wasn't a particular moment. It was just, as I was writing the book, I sort of increasingly thought, oh my God, maybe it's exactly the other way around. Like maybe it's exactly, actually, it's always sort of portrayed as if there's something happening for victims. And the court really uses this idea, we are bringing justice to victims. We are providing justice for victims. That's the language the court uses. And I'm like, but what do they actually get? They get, I mean, you know, if they're maybe a conviction, if they're lucky after many years, some token reparations, but what do they give? Like a lot of time, a lot of knowledge. And so I think it was messy, and slowly in the process, it sort of started to shift, and then I saw everything differently, as you sometimes do, right? You sort of step out of your data and you think, oh, hold on, this is all. So it has become a bit of an obsession. Sorry, now I missed your second. Whether I also observed restorative justice processes. I'm sure it's the same for restorative justice processes, and perhaps even more because they are much more participatory by nature. So then they will extract more labor from people, and then you can decide whether that's more or less problematic, depending on also, you know, how much that justice aligns with what people want, right? That's sort of part, and how much they feel they are in charge of the process rather than just sort of being sort of dragged along. I did observe sort of there is one domestic trial in Uganda, which I observed in Gulu, but that was very, I mean, against Thomas Coelho, but that was also, you know, I was there in the local court, which of course is super messy, right? It's not like the ICC at all. Like they're like tons of people in like small crowded rooms. But even there, I had to actually see it on a screen in the courtyard. And so it was funny because I was right there, but still I wasn't actually able to enter the courtroom, and the screening didn't work like the presentation today. and so it also felt actually quite distant. And they do have some victim participation as part of it, actually. But yeah, I haven't observed restorative justice processes. Thank you.
I'll take two. It's 5 o'clock. Are you happy to 2 more minutes? And then we'll take 2 more questions, and then we'll shift gear to the informal discussion.
Okay. Congratulations, Leila, and thanks for the presentation and Christina's discussion. My question is about the select of victim. I mean, we know when the International Criminal Court and the lawyers select the victims, they prefer the woman, especially with the children, to create the perfect victim. And like in your presentation, you also mentioned the victims. Lots of the victims are actually women. And what about other victims in Uganda and Rwanda, lots of the place? And I mean, do they provide the same labor in terms of different gender, different social class? What's the difference for like with their neighbor, and also what's the difficulty they were facing when they seeking justice and reconciliation? That's my question.
Thank you. I mean, I think there is a tendency as part of gender mainstreaming to focus a lot on women, especially when it comes to participation. So sort of say, oh, we really need to make sure that women's voices are heard, they have been marginalized. So I think there is a focus in all these participatory processes on women as those who have been excluded, and now we need to include them. But then, you know, the same has happened when women were included in market participation. They still had to do the work at home, and now they also had to do the work in the office or the factory. And there is that burden of participation, which I think tends to fall more on women. I think that's true. I think also when it comes to capitalist subject creation, I mean, for example, microcredit schemes famously focus on women because there's the idea that they're unproductive, but also because I think there's also the idea that they are reliable because they need to feed their kids. So they will repay the loan because they wouldn't, you know, they wouldn't do anything that could. So there's a certain nastiness in the way in which reproductive responsibilities make you also a better capitalist subject, right? And sort of you can be better disciplined and blamed through those mechanisms than men. But of course, men also participate in those processes. But yeah, my focus has been a bit more on women.
Thank you for your talk. Mine's more of a methods question. In particular, you talk about labour, and I guess going back to more classic Marxism, there's a distinction between abstract and concrete. And in particular, how do you think this distinction affects alienation, which was raised in the question whether that's the process, or how can we prevent the alienation of victims with that distinction in particular?
Yeah, I think that's a really important question, and I think I've been thinking about social reproduction work, and I think in some ways, I mean, it's obviously less alienating than work in the marketplace, because usually you have it's sort of a process that is subsumed by capitalist relations, but it's not directly controlled, right? Like, it's not that someone really oversees your home or what you do in your community. I mean, maybe they do now, but it's sort of it's a strange it's a labor that obviously feeds into the capitalist system and into the alienation and abstraction logics, but at least the unpaid version in the home, or for example for Ugandan women, you know, the more collective care they do in the community is still less alienated, because you are working with a person, right? That you're not, your product is a person and you have a relationship with that person. So it's not like in a factory where you produce a blouse and you have no relationship with the blouse, and the blouse just goes and you don't even see it as something that you did, right? That's not the same as you have with a kid, right? That is, most people see it as their kid and they have a relationship, you know, and they don't just like sell it off. So there is something about social reproduction work which makes it less alienable. Like, and I think that's also the power of it, right? That's also what makes it more resistant labor, because it's harder to fully alienate it. It's harder to fully commodify it, because it relies so much on the labor of love. There needs to be some love for people to be to sort of, you know, to be produced as people. And so yeah, so for me the social reproduction angle is more about labor that is exploitative, of course, but in some ways more resistive, because it's less controlled, and it therefore holds the hope of trying to think of how we can do that labor differently.
Okay, as I mentioned at the beginning, we have this room and we have some refreshments have just arrived, so we can by all means, anyone who wishes to can stay around and continue the discussion more informally. But we should draw this section to a close. But before we do so, we should thank Christine, and especially Leila for, well, both congratulations on the book and for a brilliant presentation of it. So thank you.